warmly welcome you to the lecture Introduction to the German Private Law, Part 3. In this unit, we will at first take a look at the law of things. While the law of obligation regulates the legal relationships between persons, the law of property, or to put it in German terms, the law of things, Sachenrecht, deals with the real rights, so-called dingliche Rechte. Real rights are the rights which persons have over things. A distinction is made between possession, in German Besitz, ownership, in German Eigentum, and the so-called limited real rights, beschränkt dingliche Rechte, which confer specific rights of use, consumption, or security in relation to a thing. The basic provisions of the law of things are contained in the third book of the Civil Code, BGB. In addition, certain provisions of general application are to be found in sections 90 to 103 BGB and special statutes. The distinction between the law of obligations and the law of things is yet another expression of the principle of abstraction and the principle of separation. In German, Abstraktionsprinzip and Trennungsprinzip. These both principles we have learned about in the Unit 2. Rights are enforceable against all the world. These rights are absolute, in contrast to the relative rights regulated by the law of obligations, which in principle only have legal consequences for the immediate parties to the particular legal relationship. For example, a contract only creates obligations for the parties to the contract. Because of the absolute nature of real rights in German law, applies the principle of publicity, in German Publizitätsprinzip, to them. This means that the existence of the right must be clear to everyone who cares to know. In the case of personal property, or in German terms movable property, bewegliche Sachen, the publicity function is served by the fact of possession. In the case of land, the requirement of publicity is fulfilled by the existence of the land register, in German Grundbuch, which is usually to be found at the local Amtsgericht, that is the local court. All rights in land should be entered in the land register. Furthermore, there is the so-called speciality or certainty principle, in German Spezialitäts- or Bestimmtheitsprinzip. This requires that there should be clarity as to who is the owner of a thing and what the extent and content of the right is. Rights on an aggregate of things can therefore only be transferred when it is clear to which specific objects the will of both parties to transfer relates. This means it is only possible to have real rights in specific individual things, not in aggregates of things. Finally, it should be noted that as a result of the various principles mentioned above, the law of things imposes a closed catalogue of rights, the so-called Typenzwang. This means that strict limits are imposed on freedom of contract in the interests of clarity and legal certainty. It is not possible to create by contract real rights other than those provided for in statute law. The provisions of the law of things also cannot be excluded by agreement. The law of things is thus characterized by a significant degree of strictness. It aims at a static ideal, in contrast to the law of obligations, which is strongly dynamic. In colloquial German, a person is often said to possess something when the speaker means to say that the person owns it. But these concepts, possession and ownership, are quite distinct from a legal point of view. It is quite possible to have possession of a thing without owning it, and vice versa. For example, the owner of a thing may lose it, thus losing possession. Any person finding it will gain possession, but not ownership. As used in the Civil Code, the term possession means the factual control of a person over a thing. Control is the key requirement. Even a person who controls a thing illegitimately, such as a thief, will nevertheless be in possession of it from a legal point of view. In such circumstances, an owner who wishes to assert that he or she has a superior right to possess the thing must generally invoke the assistance of the courts rather than resorting to self-help. This is in the interests of preserving law and order. Ownership is the central concept of the law of property. Ownership is generally defined as meaning not only the factual, but also the legal dominion of a person over a thing. Section 903 of the BGB proclaims that the owner of a thing can do as he or she pleases with it and can forbid all other people from doing anything with it, insofar as her right is not qualified by the law or the rights of others. We know various different categories of private law ownership. Sole ownership, in German Alleineigentum, is the situation where something is owned by a single person alone. If a thing is owned by several persons jointly, then one speaks of co-ownership, or in German Miteigentum. This can take the form of owning fractions of a thing. Another possibility is the joint ownership of a thing in undivided shares, in German Gesamthandseigentum. In such a case, the community of joint owners is the owner of the thing. Ownership can be gained by means of a legal transaction, but also by operation of law. For ownership of movable property to be transferred by legal transaction, there are two requirements. Both parties must be in an agreement as to the passing of ownership. We call this in German dingliche Einigung. And the thing in question must be handed over. It's called Übergabe. The latter requirement falls away if the person to whom ownership is to pass is already in possession of the thing, or if the parties agree that the old owner is to remain in possession but is to hold the thing for the new owner in the future. Generally speaking, ownership will be passed by the owner or some other person authorized to deal with the property. However, it is possible that ownership may be obtained from a person who has no actual authority to deal with the property. This is the case if the person obtaining ownership did so in good faith. We call this gutgläubig, and without notice. For example, if the owner of a thing has lent it to a borrower, and the borrower then proceeds to sell it to a third party contrary to the intention of the owner, the third party buyer will become the new owner of the goods unless he or she knew or ought to have known that the seller was not entitled to sell the goods. Thus, obtaining ownership from a non-owner is not possible if the buyer knew or ought to have known that the person purporting to transfer title was not entitled to do so. The person obtaining transfer will already be excluded from claiming that he or she had acted in good faith, if that person's ignorance of the true legal position was due to gross negligence. If the owner's loss of possession was involuntary, for example, if his or her property was lost or stolen, then once again, he or she cannot lose ownership to someone acting in good faith and without notice. In such circumstances, the law gives the claims of the owner precedence over the claims of the person attempting in good faith to obtain ownership. The process for transferring ownership of land is more complicated than the process for transferring movables. For ownership to pass, the first requirement is once again a common understanding between the parties that ownership is to pass. This is called Auflassung and has to be in front of a notary. However, to this is added the requirement that the alteration of the legal position must be registered in the land register, Grundbuch. Since the contents of the land register are presumed to be an accurate reflection of the legal position, it is also possible to acquire in good faith an absolute title to land if other persons who have rights over the land have failed to have them entered in the register. However, this possibility is excluded if a note has been made in the land register challenging the correctness of an entry. Transfer of ownership is often used to provide security for other types of claim. When movable property is transferred, the transfer of ownership can be made subject to a condition, in contrast to the transfer of ownership in land, which must be unconditional. To provide security in cases where the price is only to be paid in the future, it is common practice to make a contract of sale subject to retention of title. In German, this is called Eigentumsvorbehalt. Based on the contract of sale, the agreement concerning the passing of ownership is then reached subject to the suspensive condition that the full purchase price is to be paid before ownership will pass. Only once the buyer has paid the last installment of purchase price will he or she then become owner of the thing bought. Sicherungsübereignung, the mortgage of goods by security bill of sale, is a somewhat different transaction. Here, ownership of a thing is transferred unconditionally, usually to a creditor who requires security from the person making the transfer. The debtor, however, remains in direct possession of the thing and can use it. The creditor, who is acquiring ownership, merely obtains indirect possession. At the same time, the parties usually agree that ownership is to pass back to the debtor as soon as the debtor has completely repaid the capital and interest on the loan together with all incidental expenses. Ownership may also be acquired by operation of law if two things have been mixed or united together. This is called Vermischung and Verbindung in German. It can be gained if work has been invested in specification, processing, Verarbeitung. The finder of a thing becomes its owner by operation of law if it is not reclaimed within 6 months of his or her reporting the find to the lost property office. Ownership can also be gained by a possessor in good faith if the property in question is not claimed by the original owner before the elapse of the 10-year period of limitation which applies in such cases. This is called Ersitzung. Limited real rights, or in German beschränkt dingliche Rechte, relate to various isolated possibilities for deriving some advantage from particular things. They are distinguished in rights of use, Nutzungsrechte, and rights of security, Sicherungsrechte, and rights of administration and realization, Verwertungsrechte. Usufrucht, in German Niesbrauch, is the right to make all forms of use of someone else's property. The object of the usufruct can be land or movable property, but it could also be immaterial property rights. An easement or servitude, in German Grunddienstbarkeit, exists in the context of the relationships of two landowners to each other. A piece of land, the servient tenement, can be burdened in favor of the successive owners of another piece of land, called the dominant tenement, in such a way that the owners of the dominant tenement are accorded a right to use the servient tenement in a particular way. For example, the owner of the dominant tenement might be accorded a right for Wegerecht, over the servient tenement. The easement may also take the form of a prohibition on certain activities on the servient tenement. For example, the owner of the servient tenement may be prohibited from building above a certain height, so as to preserve the view of the beautiful valley enjoyed by the owner of the dominant tenement. Limited personal servitude, or in German beschränkt persönliche Dienstbarkeit, is a life interest in someone else's property. Another of the rights of use in land is the building lease, a heritage building right, Erbbaurecht. The purpose of this right is to make it possible to build on land without owning it. The rights of security include the pledge, pawning of goods, and possessory lien. Both are translated as Pfandrecht. The purpose of security rights is to provide security for the creditor in the event that the debtor does not fulfill his or her obligations. If the claims of the person to whom goods are pledged are not satisfied by the debtor, the creditor can instead realize the pledged asset, generally by selling it by public auction. The most common right of security over land today is a type of mortgage called Grundschuld. The land is burdened in such a way that the beneficiary is entitled to the payment of a sum of money out of the land. This means that the creditor can sell the land to satisfy his or her claim if the debtor does not fulfill his or her obligations, or, in the case of lesser debts, have it placed under compulsory administration until the debt is satisfied from the profits from the land. The Grundschuld is not dependent on the existence of the claim which it is intended to secure. In contrast, the type of mortgage called hypothek, which the drafters of the code treated as being the most important form of security over land, exists only so long as the claim which it was intended to secure exists. The realization of land, in the event that the debtor fails to pay as agreed, takes place in accordance with a strictly regulated procedure set out in a special act. Let's take a shorter look at the family law. The family law is made up of the legal rules which regulate relationships within the family. In other words, the law of marriage, engagement, the law of relationships by consanguinity or affinity, the law on adoption and on parental responsibility and guardianship. Family law is based primarily on the fourth book of the Civil Code. In the Constitution, the term marriage has the meaning of a relationship subject to the forms previously established in private law. This means that it is a relationship between two persons which is entered into with the intention that it should last for life. Since 2017, marriage between two people of the same sex is possible. However, the increasing incidence of people living together without getting married is placing the institution of marriage in question. In some legal situations, for example, In the law of landlord and tenant, the parties to an extramarital relationship are increasingly treated as if they were married. Let's take a look on the last book of the German Civil Code and the law of succession. The Constitution guarantees the right of inheritance in Article 14 Basic Law, which states that ownership and the right of inheritance are guaranteed and that the content and limits of these rights are determined by statute. The most important provisions on the law of successions are contained in the 5th book of the Civil Code. Numerous other relevant provisions are scattered throughout the law. For example, the inheritance of farms is regulated in different ways in the laws of each state of the Federation. The important rules relating to the estate duty, in German Erbschaftssteuer, which must be paid to the state in the case of succession by death, are contained in the Estate Duty and Donations Tax Act. The German law of succession is guided by 3 basic principles, namely the principle of universal succession, Universalsukzession or Gesamtrechtsnachfolge in German, the principle of testamentary freedom, in German Testierfreiheit, and the principle of inheritance by the family, in German Familienerbfolge. Freedom of testation, testamentary freedom, refers to the power of the testator to freely determine the fate of his or her property after his or her death. This power is to some extent limited by the principle of inheritance by the family. The legislator's assumption is that the deceased was close to his or her family and that in most cases they have also contributed in some way to his or her accumulation of wealth. Freedom of testation does, however, as a general rule take precedence over the principle of inheritance by the family, only insofar as the deceased has made no provision to the contrary does his or her property pass by the operation of law to his or her blood relatives and to his or her spouse. However, a certain minimum portion is reserved for the spouse and blood relatives, even if the testator has provided otherwise. In such a case, the excluded family members have a claim against the beneficiaries appointed by the testator under the will for a certain minimum share of the estate. That's the so-called Pflichtteil or Pflichtteilsanspruch. The principle of universal succession, regulated in section 1922 BGB, means that immediately on the death of the deceased, the person inheriting steps into the shoes of the deceased. That is, he or she takes over all the assets and liabilities, activa and passiva, of the deceased. This takes place by operation of law and without any formal act of transfer. The ability to inherit is dependent on having legal capacity. This means that both natural and legal persons can inherit it, but an animal cannot. In some cases, legal capacity is fictitious. For example, in the case of an unborn child after conception. This is called the nasciturus. Who becomes heir? The person whose property is in question, in German it's called Erblasser, may determine who is to benefit on his or her death by a disposition in contemplation of death, which would generally take the form of a will. If the deceased has failed to specifically appoint beneficiaries, then the rules of intestate succession operate. Only when no appropriate beneficiaries can be found does the property pass to the state. The status as heir is acquired automatically on the death of the person to whose property they are succeeding. It is thus possible for someone to be an heir without or even contrary to his or her wishes. Particularly because the heirs also assume responsibility for all the liabilities of the deceased estate, it is possible for them to renounce their inheritance. That's called Ausschlagung. In such a case, the passing of the inheritance to the heir is voided with retrospective effect. Only in exceptional cases is it possible to renounce only a part of the inheritance while accepting the rest. The heir is liable to the full extent of his or her own assets for the liabilities of the deceased estate. The heir does, however, have the options of placing the estate under administration on behalf of the creditors, so-called Nachlassverwaltung, or of having the estate declared bankrupt, Nachlassinsolvenz. In such a case, the inheritance is kept separate and the liability of the heir with respect to the creditors of the deceased is limited to the extent of the assets inherited. If several people are heirs to the same estate, they are called joint heirs, Miterben. They then form a community of joint owners of the estate, a so-called Erbengemeinschaft. This is a form of Gesamthandsgemeinschaft. Each heir then has a share in the estate, which is separate from the rest of his or her property. Each heir can deal with this share as such, for example, by selling or donating all or part of it. However, only the community of joint owners as a whole can make decisions as to what is to be done with specific assets in the deceased estate. Estate duties, so-called Erbschaftssteuer, must be paid on any inheritance. On the other hand, an inheritance is not subject to income tax. Donations tax and estate duties are regulated in the same statute and essentially in the same way. The amount of estate duty payable depends on the degree of relationships between the beneficiary and the testator or intestate deceased. Besides the general private law, which is regulated mostly in the civil code, we have several special private laws. Commercial law, or in German Handelsrecht, regulates the relationships between business people, Kaufleute. It is a specialization of the private law which aims to provide for specific needs of commercial life. For example, taking into account that the business person needs less protection than an ordinary consumer and greater freedom of contract. The field of commercial law includes not only the buying and selling of goods, but also other areas of business life such as the transport, banking and insurance industries, and manufacturing and craftsmanship. The German system of commercial law, in the narrow sense in which the phrase is often used in Germany, applies specifically to the businessman or merchant, in German Kaufmann, who has this status, and what legal consequences follow from it is defined by the law. It is thus in principle a subjective system of special rules applicable only to business people. Since commercial law regulates a sphere of life in which businesses, enterprises play a major part and in which the individual business person often only plays a secondary role, commercial law is often also referred to as Business Enterprises Law, or in German Recht der Unternehmen. It is mainly regulated in the Commercial Code, Handelsgesetzbuch, HGB abbreviated, which came into force simultaneously with the Civil Code on the 1st of January 1900 and has been amended many times since then. In addition, there are numerous other relevant statutes. The Commercial Register, Handelsregister, satisfies the need for publication of important commercial information. In this register, which is kept by the Amtsgericht, the local court, relationships such as authority to represent the firm, the place of business of the firm, and its name are recorded. Third parties are entitled to assume that every entry in the register is correct and still valid until a change has been entered into the register and made public. In addition, the HGB contains regulations on general partnerships and limited partnerships, OHG and KG. They are a part of company law. Company law regulates the law of companies. In German jurisprudence, company law refers to the field of law that deals with associations of persons under private law that are established by legal transaction in order to achieve a specific purpose. We will deal with company law in later units. Labor law. The relationship between employee and employee involves numerous special problems for which the law must provide solutions. A key consideration here is the personal and economic dependence of the employee. This is the justification for the principle of protection, which is a guiding principle of the rules of labor law. Many of the provisions of labor law are binding and can be only varied in favor of the employee. Labor law consists partly of private law and partly of public law, and provides a clear instance of the limited practical usefulness of such theoretical classifications. A distinction is in labor law generally made between employment law, or in German Individualarbeitsrecht, individual labor law, and the law of industrial relations, Kollektivarbeitsrecht or collective labor law. Employment law governs the private law relationship between employer and employee. It also includes statutory rules on worker protection, which have strong public law elements. Examples are safety measures in the workplace, maximum hours of work, and the prohibition of child labor. The law on industrial relations, on the other hand, is concerned with the types of association which are relevant in the employment sphere, unions and employers' associations. It also includes the law on industrial disputes, on collective agreements between the various associations, for example, the agreements arising from industry-wide collective bargaining, on employees' rights of representation and co-determination. Labor law is governed by numerous different statutes. There is no code on the subject. A particular characteristic of the German labor law is that wide areas of it are not regulated by statute at all. The courts, therefore, regularly base their decisions directly on the Constitution. In particular, the values set out in the fundamental rights are often drawn up in forming and interpreting the rules of labor law. The courts, particularly the Federal Labor Court, Bundesarbeitsgericht, have created a considerable body of judicial precedent which undergoes constant development. Finally, the collective bargaining agreements reached by the unions and the employers' associations regulate many aspects of labor relations.